What is pre-proclamation controversies? A pre-proclamation controversy refers to any questions pertaining to or affecting the proceedings of the Board of Canvassers which may be raised by any candidate or by any registered political party or coalition of political parties before the board or directly with the Commission. It is intended to prevent the nefarious practice known as the grab the proclamation, prolong the protest. The pre-proclamation controversies generally covers only two issues. First is the illegal composition of the Board of Canvassers, which exists when any of the members does not possess legal qualifications and appointments. Second is the illegal proceedings of the Board of Canvassers, which exist when the canvassing is a sham or a ceremony, the result of which are predetermined and manipulated when there is precipitate canvassing, terrorism, lack of sufficient notice to the members of the Board of Canvassers, or if there is improper venue. Generally, these pre-proclamation controversies are allowed only in local elective positions. It is not allowed in election for national offices such as for President, Vice President, and members of Congress. It is also not allowed in barangay elections. First, when it appears that any certificate of canvass or supporting statement of votes by cities or municipalities or by precincts bears erasures or alterations which may cast doubt as to the veracity of the number of votes stated herein and which may affect the result of the election. Second, when there are correction of manifest errors. Manifest errors refers to one that is an open, palpable, incontrovertible, and needing no evidence to make it more clear, meaning it is visible to the eye and it is obvious. It can be done through a petition for correction of manifest errors and nullification of proclamation. The National Board of Canvassers is limited only to examine the election returns on their face, and as a general rule, it does not need to go beyond the face of the returns. And lastly, when the matters relating to the composition or proceedings of the Board of Canvassers.
What is an electoral tribunal? There are two kinds. First, the Presidential Electoral Tribunal. According to the 1987 Constitution, the Supreme Court en banc shall be the sole judge of all contests relating to the election, returns, and qualifications of the President and the Vice President, and it may promulgate its rules for such purpose. Second, the legislative shall have electoral tribunals as well. They are called the House of Representatives Electoral Tribunal or the HRET and the Senate Electoral Tribunal or the SET. These tribunals shall be the sole judge of all contests relating to the election, returns, and qualifications of its members. Who comprises these tribunals? For the first type of the electoral tribunal, it shall be composed of 3 justices of the Supreme Court to be designated by the Chief Justice. For the legislative, it is 6 members of the Senate or House of Representatives who are chosen based on proportional representation from the political parties and parties under the party list system. Now to matters relating to appeal. The decisions of the HRET and SET may be appealed. The remedy is a petition for certiorari under Rule 65 of the Revised Rules of Court to the Supreme Court. This is on the grounds of grave abuse of discretion amounting to lack or excess of jurisdiction or violation of due process. For the decisions of the COMELEC, it may be also appealed to the Supreme Court within 30 days from the receipt of the decision through Rule 65 on the ground of gadalage or violation of due process as well. If there are decisions made by the Regional Trial Court and the Municipal Trial Court, these shall be appealed exclusively to the COMELEC, and such decision of the COMELEC shall be final and executory.
An election protest is an election contest filed by any candidate who was voted in the same position or office, who placed second or third in votes, or in a multi-slot position, who placed in the next 4 following the last rank winner duly proclaimed. The grounds are either fraud, terrorism, any irregularities, or any illegal acts committed before, during, or after the casting and counting of votes. The prescribed filing period shall be 10 days from the proclamation of results of the election. It shall be stayed or suspended if there is a pending pre-proclamation controversy found between the same parties. The second type of election contest is the quo warranto. A quo warranto under the Omnibus Election Code It is a proceeding to unseat the ineligible person from office. It may be filed by any registered voter in the constituency. The grounds are ineligibility from office or disloyalty to the Republic. It shall be filed within 10 days after proclamation of the results.
When must an election contest and protest be filed before the COMELEC? It must be filed within 10 days from the proclamation of the election results, which shall be suspended pending a pre-proclamation controversy involving the same parties. Thereafter, the Director of the Election and Adjudication Department shall docket the protest and raffle the case. But what happens next? The corresponding summons shall be issued within 3 days from filing together with a copy of the protest, requiring the filing of an answer within a non-extendable period of 5 days from notice. But should a preliminary conference be held? Definitely yes. The COMELEC shall conduct a mandatory preliminary conference among the parties within 3 days from the filing of the last responsive pleading, followed by the manual and visual recount of ballots shall commence on the date specified in the preliminary conference. But what follows? The order of hearing whereby the protestant must present evidence in support of the protest. The protestee must adduce evidence in support of his or her defense, counterclaim, or counter-protest. And the parties may offer rebutting evidence unless the COMELEC permits them to offer evidence upon the original case. Finally, the COMELEC shall decide the election contest and protest within 30 days from the date it was submitted for a decision.
Before the filing of the election protest, ask these key questions. Did the COMELEC have jurisdiction over the subject matter? Is the protest sufficient in form and content? Did I file on time? And last, did I pay my fees on time? If the answer is in the negative, you might want to reconsider because it's a ground for summary dismissal of an election contest. Afterwards, summons. After the service of summons within 3 days from filing, the respondent is actually required to file an answer within a non-extendable period of 5 days from notice. After the filing of last responsive pleading or expiration of period without any responsive pleading filed, the Commission shall conduct a mandatory preliminary conference among the parties. So what happens there? It's where the parties simplify the issues, consider the necessity of amendments to the pleading. It's also where they ponder the possibility of obtaining stipulations or admission of facts and of documents to avoid unnecessary proof. When will the recount of ballots start? It will start on a date specified in the preliminary conference order unless rescheduled. Lastly, there's this concept of continuous recount, where once the recount of ballots is commenced, the recount shall continue from day to day until terminated. When is the presentation or reception of evidence? The reception of evidence on all matters shall be presented and offered in a hearing upon completion of the recount of ballots or tabulation of election documents or technical examination, if warranted.
The hearing of the evidence will be held in the following order. First, the protestant shall present evidence in support of the protest. Next, the protestee shall then adduce evidence in support of the defense, counterclaim, or counter-protest, if any. Lastly, the parties may then respectively offer rebutting evidence only, unless the Commission, for good reason in the furtherance of justice, permits them to offer evidence upon the original case. No rebuttal evidence shall be allowed. What are the 3 main types of disputable presumptions in election contests? Matters on the election procedure, election paraphernalia, and the appreciation of ballots all have presumptions that may be disputed. What is the effect of the death of the Protestant in an election protest? The death of the Protestant does not necessarily extinguish an election protest. Why is this so? An election protest is above an ordinary civil action, as it is imbued with public interest. It involves not only the adjudication of the private interests of the rival candidate, but also the paramount need of dispelling the uncertainty that beclouds the real choice of the electorate. When is an election protest deemed abandoned? An election protest is deemed abandoned when the protestant assumes office, or when the protest is withdrawn, or when the determination to protect and pursue the public interest involved in the matter of who is the real choice of the electorate is abandoned.